Well, over in district court, even a federal judge today expressed concern for the blanket denials of H2B visas in the last year, noting that it goes against the wishes of Congress when it comes to the military buildup. This was expressed during the first hearing for the H2B lawsuit, in which local contractors are seeking reversal of those denials. Here's more. It's not that Guam doesn't have the ability to learn the construction or skilled labor trade to be able to provide the labor needed for local projects that would contribute to the economy. It really boils down to how much we can offer. That, according to attorney Jeffrey Joseph, who argued in district court today on behalf of the Guam Contractors Association and several local contractors suing the U.S. Immigration Service. The parties were in court to present oral arguments on a motion for preliminary injunction being sought by GCA. The injunction would allow for the reversal of the denial of H2B petitions over the last year. Joseph pointed out that Guam Department of Labor is tasked with certifying these petitions before they're sent to the U.S. Citizenship and Immigration Services out of California for approval. And the process for certification is a rigorous one, he said, even more rigorous than that of the U.S. mainland. Joseph also says that the government makes a mistake of basing these petitions on the job, when really, he said, it should be based on the employer's needs. Joseph pointed out that at one point the federal government understood Guam's unique position when it came to foreign labor, that in 1985 the regulation was changed for Guam's prevailing wage and a cap on the amount of foreign labor was lifted. In the U.S. mainland, there is still a cap of 66,000 foreign workers. But U.S. Magistrate Judge Joaquin Manabusan questioned attorney Joseph on the definition of peak load need, which is the category under the H2B program that has been denied over the last year. The judge acknowledged that the H2B program was not meant to recruit foreign workers for permanent jobs, but it seems that after 30 years of approvals, Guam still hasn't been able to supplement its own workforce with local hires. Quote, "Is that the image we want to show for Guam, that we can't have masons or carpenters? If we have been training them for the last 50 years, how do we not have workers?" he questioned. And that, according to Joseph, is a telltale sign of an even bigger problem. Locals are trained for local jobs, but because other jurisdictions, like Hawaii, offer 40% more in wages, most of those who train in Guam end up leaving the island. And with an impending military buildup, without labor, Joseph says, quote, "we will shut down." In addition, Joseph argued that while Guam DOL acts as an advisory when it comes to certifying the H2B petitions before sending them up to USCIS in California, deference should be given to Guam. Essentially, he says Guam should have the upper hand in determining whether the petitions are legitimate because, quote, "there's no way someone in California can understand the needs of Guam for labor. No one can understand better than Guam DOL, not an adjudicator in California," end quote. When it came time for the defense to present oral arguments, attorney Glenn Gerdhary acknowledged that the situation these denials have created are, quote, "unfortunate." But he also notes that GCA is asking to change the status quo. However, even Judge Manabusan pointed out that the lack of skilled workers on Guam is real and that after World War II, very few large facilities were built without foreign labor. Judge Manabusan then emphasized that it was, quote, "disturbing that Congress has said that they want to relocate Marines to Guam and we need to have certain facilities built and certain things done. But if we don't have the workers, what are we going to do?" end quote. To that, Gerdhary said there is no definitive connection between the military buildup and the H2B program. Quote, "that complaint belongs in the halls of Congress," Gerdhary told Manabusan. Judge Manabusan then pointed out that Congress is also the body that gives the USCIS the authority to approve or deny the H2B petitions. Judge Manabusan took the motion under advisement.